Hi there, I'm attorney Kelly Longtin from Kelly Longtin Law, where we provide effective estate planning for everyday families in Massachusetts and New Hampshire. And today I want to talk to you about who should be the trustee of a third-party special needs trust. Now, family members with special needs may require assistance throughout their lives. If you want to ensure that a loved one with a disability is taken care of after you're gone, you can help manage resources for them by using a third-party special needs trust. It is also known as a supplemental needs trust. A third-party special needs trust is funded with assets, either money and property, that do not belong to the special needs beneficiary, but are meant to be used for their benefit. Third-party special needs trusts allow the beneficiary to receive some benefit from the trust while preserving the beneficiary's eligibility for means-tested public assistance programs such as Medicaid and Supplemental Security Income, or SSI. When the beneficiary passes away, whatever funds remain in the third-party SNT or special needs trust can pass to other family members. Choosing the right trustee to manage a third-party SNT is a crucial decision. The person selected for this role must understand their responsibilities and fulfill them in a way that does not jeopardize the beneficiary's government benefits. Now, there are two main types of SNTs. There's first-party SNT and third-party SNT. Both are intended to ensure that a person with a disability or functional needs can receive financial support from the trust while preserving their government benefits. What differentiates these two types of trust is the source of trust funding and the government's entitlement to a portion of the trust funds. First-party SNTs are funded with first-party money, meaning the beneficiary's own assets. Typically, this type of SNT is set up by a person with special needs if they receive a windfall, maybe a personal injury or a medical malpractice settlement, or if they become disabled at a time when they have significant assets but need to qualify for mean-based benefits. Now, third-party SNTs are established by a parent, grandparent, sibling, or other person and funded with their assets rather than the assets of the beneficiary, including money, life insurance policies, real estate, and investments, to benefit a family member with special needs. A third-party SNT can be created in a couple of different ways. First, you can have a standalone third-party SNT, and that's created during the lifetime of the trust maker. It's effective immediately upon the creation, and it remains effective after the death of the trust maker. It is eligible to receive assets from multiple sources during and after the trust maker's lifetime. Now, a testamentary third-party special needs trust is created as part of a person's last will and testament and does not come into existence until the person who created the will passes away. At the time of death, designated estate assets are transferred to the trust, and the individual with special needs becomes the beneficiary of the trust. Whichever type of SNT is created, whether it's first party or third party, standalone or testamentary, the assets in the trust are legally owned by the trust, not the beneficiary. As a result, the special needs beneficiary is not disqualified from SSI or Medicaid, which have income and resource limits for enrollees. There's an important difference, however, between first party and third party SNTs in terms of government benefit reimbursement. In a first party SNT, when the beneficiary dies, the state Medicaid agency is entitled to reimbursement for the full amount paid on behalf of the beneficiary during their lifetime. This could mean fully exhausting the remaining trust funds to repay state Medicaid programs. Only after Medicaid reimbursement has been satisfied can the trust balance be distributed to other beneficiaries named in the trust by the trust maker. This Medicaid repayment obligation does not apply to third-party SNTs because the assets it contains never belong to the beneficiary. When the beneficiary of a third-party SNT dies, all the remaining assets can pass to other named beneficiaries. Ultimately, the government will not get any portion of those trust funds. So let's talk about the responsibilities of a third-party SNT trustee. Once the decision is made to create a third-party SNT, the next and equally important decision is to select someone to serve as trustee. The trustee is the person responsible for managing the SNT on behalf of the disabled beneficiary. They administer the trust and manage its assets according to the trust terms. More than one individual can serve as a trustee. A trustee can also hire an attorney or other professional to help them meet their legal duties. A trustee has a fiduciary duty to act in the best interest of the trust beneficiary. Broadly, in the SNT context, they are required to ensure the beneficiary remains eligible for government benefits by providing additional financial support from the trust for specific and limited purposes. For example, the trustee may use the trust funds to supplement the beneficiary's government benefits, but not replace or duplicate them by distributing funds to pay for things like education, recreation, and vacations. A trustee's duties can include handling trust distributions to the beneficiary, overseeing investments of the trust assets, maintaining trust records, filing the trust taxes, and communicating with the beneficiary and other involved family members. Third-party SNT trustees have a huge responsibility. Among other things, they must understand the rules and regulations surrounding government benefits and allowable distributions. Using an SNT to provide cash or cash equivalents to the beneficiary or to pay for the beneficiary's food or shelter could disqualify a beneficiary from public benefits. In all trust-related matters, the trustee must act to ensure the beneficiary maintains the highest quality of life possible. Failure to uphold their fiduciary duty could not only harm the beneficiary, but also lead to legal action against the trustee. A new trustee may have to be named. If estate planning documents do not name a successor trustee, the court may need to appoint somebody to serve as trustee. Special needs trusts have highly technical terms and administrative requirements, and the rules governing them are very complicated. A simple mistake on the part of the trustee could unintentionally hurt the beneficiary. A layperson named as the trustee of a SNT can hire an attorney to provide guidance and assistance. They may need to do so to satisfy their fiduciary duty and make sure the disabled beneficiary receives appropriate support. Attorney's fees can be paid out of the trust. Alternatively, an SNT can designate a professional trustee to oversee the trust. Hiring a professional trustee can increase trust costs, but a trustee who has experience with SNTs may be better suited than a family member to fulfill the trustee's many important responsibilities. A special needs attorney that focuses on special needs can be a great asset to you and your family. I want to thank you for watching, and I hope you found this beneficial, especially when it comes to special needs beneficiaries. I'm Attorney Kelly Longtin, founder of Kelly Longtin Law, where we provide effective estate planning to everyday families located in Massachusetts and New Hampshire.